Let me switch gears for a minute, John. I read that if, let's say for instance, and I forgot about the dram shop, BJ. Let's say BJ had a party and we were at his house. Does he have to inform me of if there's something wrong with the step in his house? Because if I slip and fall, what happens in a situation like that?
If he knows he has a faulty step, say leading up to his deck, and invites you to a party, knowing that you're more than likely going to be going up and down that step, he has a duty to warn you. But let me tell you, if you've been to his house a dozen times and been up and down that same stairway, then the law is probably going to say, well, Annette, you've been up and down this thing, you were in a position to notice it. In other words, your knowledge would be just the same as his at that point in time. But if you haven't been there and he's got a problem and he doesn't know about it, he's got a duty to tell you.
Okay, okay.
The duty's different coming to my house for a party than if I owned a grocery store and you came there and were injured. The law's different. You're an invitee at the store, you're a licensee at my house. And what the law requires of the property owner is different depending on the status of the plaintiff.
To fix his, yes, if he invites you if for a business purpose or that sort of thing, then he's got a duty to fix that step.
Okay, and speaking of the business, it's not as simple, PJ, as a lot of times we see the yellow sign, the wet floor sign. So is it as simple as putting up the sign sometimes?
Well, what the deal is, you have to exercise reasonable care to protect your customers, and that may be sufficient under the circumstances. If it's there's been a leak out of a maybe a frozen bin or some ice had melted and there's a steady leak there, and they keep the sign there, but it doesn't adequately warn of the dimensions of the spill, it wouldn't be an adequate type thing. But it can be. That's what John was talking about earlier. All these cases are so factually specific because the same spill or substance on the floor may be something you can sue for in one instance and not in another.
Okay. Okay.
That's why you need a lawyer, and the lawyer will know what questions to ask, and it's quite, the key thing is the superior knowledge as between the plaintiff and the store owner, who has more knowledge.
Okay.
And that's pretty easy to determine when you talk to your client.
Gotcha.
Whether
Okay.
you'll have a chance or not. They are tough cases, so.
Okay. We're going to take one more break, everybody. Stay with us.
Opinions expressed on Law Call are those of the participants and do not necessarily reflect the opinions of 13 WMAZ staff or management, nor any legal or judicial entity. The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid.